For admission, item number 1 and 2.
This is yes,
Your Worship, this is a bill application which was part heard yesterday.
part had.
Yes, Your Honor.
Okay. So just let us see the FIR ones. Allegation. Okay, this is stop for checking and then the total. Okay, your ground for bail is earlier bail rejected
In 2 occasions, Your Worship.
2 occasions.
Your Worship.
Just a minute. Rejected on
24th, 7th, 2025 and 4th, 11th, 2025, Your Worship.
25.
24th, 7th, 2025, 4th, 11th, 2025.
Have you annexed?
My annexer is Annexer E,
Okay.
page 29
24.
to 31.
And the other one is next.
Annexer E1, page 31.
Okay. So, and then this is under section 21C.
21C, Your Worship. 21C, 29/60 NDPSA.
Okay. Arrested on
Arrested on 11/4/2025.
11/4/2025. How many of you were arrested?
4,
4 of you.
Your Worship. The
Okay.
3 alleged accused persons were arrested on 16/8/2024.
3 accused were arrested on 16/8.
16/8/2024.
And you were arrested
And
on
I'm arrested on
11/4.
11/4/2025, Your Worship.
Okay. This is the case. Is this the case where you are not? Okay. You were arrested on the basis of the disclosure statement.
Yes, Your Lordship.
Okay.
And my grounds for bail is on page 5 of my petition, paragraph 7. Page 5,
Okay.
paragraph 7. This is my ground, Your Worship. That there is nothing on record to show that the grounds of arrest were communicated in written to the accused and his relatives, friends, or family of the accused, and that the same has been acknowledged
Nothing
by
on
the...
record. Okay.
Yes, Your
Not
Lordship.
communicated.
Yes, Your Lordship.
But then, yes, I have heard you earlier. So, the grounds communicated.
Your Lordship, I've perused the record and it looks like it was not there on the record regarding the grounds of arrest. So,
Is it?
Your Lordship. And the aspect of ground of arrest, we have to go by the records. We cannot go beyond that.
Not communicated.
Those documents are not found.
In which case? Okay. Recovered, just a minute. Okay. Okay, hard. Mr.
Division of
Planning Counsel for the petitioner. I will also had Miss Mary Lana PP for the state. Stop. The case of the petitioner is that accused, what is his name?
A Kaiser.
A
A Kaiser.
was arrested on 11/4,
11/4/2025
in connection with narcotic PS case number 14, 2024 under section 21C and 29/60 of the NDPS Act 1985. Stop. The earlier two bail applications moved before the trial court have been rejected on 24/7/2025 and 4/11/2025 by 25. In this bail application, the petitioner is seeking release of the accused. In this bail application filed under 483 of the BNSS 2023, the petitioner is seeking release of the accused on bail on the following grounds. One, that no ground of his arrest were communicated in writing to the accused at the time of his, to the accused and his relatives, friends or family at the time of his arrest. As such, the same is gross violation of Article 22(1) of the Constitution of India and Section 47 and 48 of BNSS 2023, rendering the arrest of the accused illegal. Stop. 2. That upon completion of investigation, the investigating officer has already submitted the case into charge sheet against the accused on 14/7. Is it the date?
Yes, Your Lordship.
7/2025. And the matter is pending at the stage of consideration of charge. Stop. As such, the custodial remand of the accused is no longer required for the purpose of trial. Stop. Para. Miss Mary, Lana PP fairly submit on record that there is nothing on the record to show that the grounds of arrest were communicated in writing to the accused and his relatives, accused and his relatives, friends or family at the time of his arrest. Stop. Okay, then I'll pass the order. Okay? It will be granted on technical only, not on merit.
Not on merit, just on the technical ground.
Yes, yes.
My lord, in the second petition, that is item number 2, the name, the date of arrest in the bail application rejection order, that will be different.
Item 2.
Yes, my lord.
Okay, here,
Arising out of
here
the same
then the name of the counsel will be Takakichu, and then the name of the person will be James Niwei.
My lord,
Name of the accused would be
Manizo,
Manizo,
Manizo, and the date of arrest would be
16/8/2024.
16/8/2024. Okay.
And bail application rejection order is 22/10/2025.
Then bail application rejection order twice.
No, only once.
Only once. 22,
22/10/2025.
25. Okay. Then I'll pass the operative portion. Okay.
Item number 3 and 4.
Yes. Yes.
Your Lordship, I'm for item number 4.
But yes, here.
3 has to be taken up. What about item number 3, Your Lordship?
3. Yes, 3.
3.
You are in item.
4, Your Lordship, 4.
Who is for 3?
I saw the council around.
Okay, let us take up the 4. Item 4. The case, okay, 4 and 3.
Your Lordship, I'm for 3.
3.
Yes, Lordship.
Okay. Okay, we'll wait for you. Go out. Manage it. Don't worry. Yes, we'll carry on with item 4, okay?
May I please, Your Lordship?
Yes.
Your Lordship, this is a bail application under 483 of Benes's praying for release of accused Kohima on bail.
You're in in item 4.
Yes, Your Lordship.
Okay. Here also, your ground for bail is,
On,
it was not communicated.
yes, Your Lordship.
Any other ground?
No, Your Lordship.
Okay, then
Purely on gross violation of the mandatory requirements given under 47 and 48 of...
just a minute. Just a minute. This is under section 20
20B,
B and C.
20B, clause
No, it's
C.
B.
Yes, B and C.
I
B and
think B is
20 plus B and C.
how it can be. The one is the B applied to the another accused, and C would be for the another accused, because there was 2 vehicles in here in this case. There were 2 vehicles, isn't it?
Yes, Your Lordship.
Okay, the one the accused arrested from one vehicle would be under 20B, and the other one would be, the gypsy one would be 20C, isn't it? But B and C, how it can be for one person? Read with 61 BNS.
Yes, Your Lordship.
Okay. He was arrested on
I'm arrested on 2nd of May 2025, Your Lordship.
he was driving which vehicle?
Your Lordship, the accused was driving the gypsy, Your Lordship.
Gypsy.
Yes, Your Lordship. Your Lordship
Okay, earlier bail applied,
applied on 12th of...
rejected on 12.
Yes, Your Lordship. Rejected on 12th November 2025, Your Lordship.
On 12,
November 2025, Your Lordship.
2025. Once only?
Yes, Your Lordship.
Only once?
Yes, Your Lordship.
Arrested on 2/5. 12/11. It was on merit only?
No, Your Lordship. Your Lordship, I'm coming on the grounds of violation of... violation of
Where
the grounds.
is the bail rejection order?
Your Lordship, page 30 of the petition, Your Lordship.
30.
Yes, Your Lordship. Lordship, this bail petition was rejected only on the grounds that charge sheet has been filed and cognizance have been taken.
Grounds of arrest was,
The earlier bail petition was rejected only on the grounds that charge sheet was been filed.
Okay, charge sheet file on?
Charge sheet file of 8th of October 2025, Your Lordship.
Trial began?
No, not yet, Your Lordship. CC has yet to be taken.
Okay. And then your ground for bail is
It's-
non-compliance?
Yes, Your Lordship. It's given under page 5 of my petition, Your Lordship. Violation of section 47 as well as 48 of BNSS, Your Lordship.
Violation of, okay.
Your Lordship, at no point of time, neither at the time of apprehension or thereafter, was any written documents or notice furnished to the accused explaining the grounds of arrest. Your Lordship, this is a clear violation of mandatory requirements under 47 as well as 48, along with Article 21 and 22, Clause 1 of the Constitution of India. Lordship, obligating the arrest authority to inform the accused of the grounds of arrest forthwith, and hence this procedural failure renders the arrest patently illegal and amounts to a violation of accused fundamental right.
Yes. And any other?
Your Lordship, this present case, even the public prosecutor has clearly admitted that the grounds of arrest was not formulated against the accused during the time of arrest, Your Lordship.
Yes. Is it the same case, Ms. Mary?
This is arising out of different FIR, but then the record has been called, so I'll be relying on the record.
Okay.
Yes.
Ground communicated?
Grounds communicated or not, that will be determined from the record.
What is his name?
Accused Kuvini, Your Lordship.
Kovini.
Kubini.
Yes, Your Lordship.
Kubini was communicated on 3/5/2025. She has acknowledged, she or he, Kubini is?
He, Your Lordship.
He has acknowledged.
Your Lordship, during the time of arrest, as well as even thereafter, the grounds of arrest were not communicated to the accused person. And the
So
grounds of arrest...
according to you, it was subsequently communicated.
Yes, Your
But
Lordship.
then he has acknowledged it.
No, Your Lordship, this came along with charge sheet, Your Lordship. And I've received the grounds of arrest only on 28/11/2025.
He has signed
Your
it.
Lordship.
He has signed it.
Your Lordship,
Signed date is 3/5/2025.
Your Lordship, it was not there from before, Your Lordship. And on
No
the
idea.
same ground, one accused has been granted bail, Your Lordship. Accused two has been granted bail on
But
the same ground.
subsequently it was communicated and he himself has acknowledged it.
No, Your Lordship. No, Your Lordship.
I have been informed, conveyed about the basic fact constituting the ground of my arrest in a language I understand.
Your
See,
Lordship, may kindly consider this ground because Your
it was
Lordship,
subsequently communicated, even if it is subsequently also. But then
Your
it was
Lordship-
communicated and he himself has acknowledged. received and acknowledged it.
Your Lordship, it may have been communicated later on, but that will not cure, Your Lordship, the violation that
Can
has
it
been.
cure
No, Your
subsequent
Lordship.
communication?
No, Your
Can
Lordship.
it be cured?
Your Lordship, there is a latest judgment where it says that within 2 hours before the production, before the magistrate, that has been.
No,
that has
you
to
see,
be
here is the case
communicated, but I don't remember.
where we do not know when, but then subsequently it was communicated. Initially, it was not communicated,
It should
but
be
then
reasonable,
subsequently it
within
was
a
communicated.
reasonable time. If it is communicated, then
It was communicated,
it will amount
subsequently,
to compliance. Yes, yes.
and then he has acknowledged it, put his
Yes, yes.
signature.
If that's the case, it will amount to the compliance of Article 22.
So it appears that it was complied.
If that is on record, then yes.
Your Lordship,
Yes.
for this I'll rely on.
It is not a case that where he was never communicated, but then subsequently also he was communicated. He has received and put his signature,
No, Your Lordship.
acknowledging,
Your Lordship, I have.
and then
Your
and
Lordship,
says that he was
regarding-
explained in the
regarding the
language
grounds
which
of arrest.
he understood.
Your Lordship, regarding the grounds of arrest, they have taken the signature of the accused person only from the jail, Your Lordship. And before also from the inception of the arrest, there was no grounds of arrest, Your Lordship. And on that ground, one accused has been granted bail, Your Lordship.
Now you see that could be a miscommunication. The records were there. It was not communicated properly before the court.
Your Lordship, may I
Please.
state, rely on Article 22 of the Constitution of India, protection against arrest and detention in certain cases, Your Lordship. In clause 1, no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds of arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. Your Lordship, if we come to my accused person, he has never got the opportunity to even consult a legal practitioner representation, Your Lordship.
See, here is the case. Have you seen this, page 7? Here is the case where subsequently, probably it was not immediately, but subsequently it was communicated, explained, and he have understood and put his signature acknowledging that he has been communicated. Information to the family also.
Lordship, that was prepared and kept only at the later stage, Your Lordship. And I have come
Maybe after, immediately after the arrest, it was not communicated, but subsequently it was communicated. But due to miscommunication, if the bail was granted earlier to some other accused persons, so that's
Your Lordship, in the last
not the
occasion
fault,
where bail was
because-
granted, Your Lordship, the session, district and session trial court has even clearly given in the bail order that, Your Lordship,
rightly or wrongly, granted, rejected, we have no idea. But then here is the case where we could see that he has acknowledged the communication.
no, Your Lordship, the information to the family also, there is no acknowledgement, Your Lordship, there is no signature also, there is no signature. The family of the accused person has not been acknowledged, Your Lordship. And even in the earlier grounds also, Your Lordship, the court has stated that on perusal of the case record, the grounds of arrest in any written form is not found. Your Lordship, this has been clearly stated, Your Lordship.
Yes, what is your submission?
Your Lordship, he can't be
Your
detained without his grounds of arrest, Your Lordship.
I'll have to go by the records.
Go by?
Go by the records, which has been.
The record, as per the
Yes.
record is acknowledged.
So then there is a compliance.
No, Your Lordship. Your Lordship may kindly, I beg this honorable court to kindly consider this area.
See, the recovered item, the recovered contraband substance is 370.6 kgs, almost 4 quintal. Okay,
Your Lordship,
hard, miss. Hard miss?
Krike Tonyo.
Okay. Cricket Honyo, Land Counsel for the petitioner. That is in item 4. Huh? The beginning would be same, huh? And the ground also would be arrested under section for offense under section. The applicant is
Applicant is T.H. Leah.
yeah, okay. In connection narcotic PS Kohima case number 0002 stroke 2025 under section 20 stroke B middle bracket C stroke 60 of the NDPS Act read with section 61 BNS 2023. Okay. He was arrested on 2/5/2025. His bail was rejected on 12/11/2025. Charge sheet filed on 8/10/2025. Now it is at the stage of CC, huh? And the ground also would be same. It is not communicated, thereby violated section 47 and 48 of the BNSS. The BNSS read with section 21 and article 21 and 22 of 21 and 22(1) of Constitution of India. Then in the submission of the per contra Lanet PP submits that submitted on record submitted that the grounds of the arrest of the accused in format for information format ground arrest in the ground of arrest of the accused in compliance with the constitutional mandate under under Article 22(1) of the Constitution of India and statutory provision under Section 47 BNSS was communicated to the accused and his family on 3/5/2025, to which 2025 staff the record further reveals that the accused himself has acknowledged the receipt, acknowledged stating that he had been informed about the basic fact constituting the grounds of his arrest in a language he understood, in the language he understands, and had acknowledged the receipt of the said document. Okay, then conclusion part I'll dictate. Okay. Yes. Yes, Partner Chabo is same. Yours is the case where you were arrested
On the disclosure statement by the
on a disclosure statement, and in your case also, there is on record that you were informed about the ground of your arrest.
Lordship, I'm not pressing on the ground, Your Lordship.
Okay, not pressing on the ground.
Yes.
And then what?
I'm relying on two judgment since no recovery was affected from my position. So yesterday I relied on two judgment which I've submitted.
What
to
is
Your
it? What
Lordship.
it says?
Your Lordship, one is Sachin Mehta versus Narcotics Control Bureau, and the other one is Subhas Vikrant Singh versus State of Punjab. In Vikrant Singh, I relied on paragraph 5, 11, and 12.
Which case?
Vikrant Singh versus State of Punjab.
Vikrant Singh. Para 11, 5, 11,
Paragraph
12.
5, 11, and 12, Lordship.
What it says?
Lordship, may I read?
Operative portion, since there is no recording of conversation.
Yes, Lordship.
Okay,
It says that
conversation, okay, the exchange between the co-accused. Mere call details, okay. Cannot be considered to be the corroborative material.
yes, in
Okay.
absence of substantive materials found against the accused.
Okay, and then in the next para 7, 9, and 10.
In Vikrant
CDR
Singh,
between the
yes,
applicant and the co-accused
5,
person
9, 11.
per se at this stage do not suffice to establish the existence of the conspiracy, okay? But then that is the matter to be decided
Your Lordship,
in trial only.
yes, Lordship. 3 persons were arrested earlier.
Yes, then you can take
Yes.
this plea during trial. And then you are the person, these 3 persons, isn't it? Total
Yes,
4.
Your Lordship.
All of these 3 persons stated that it was to be delivered to you.
Yes,
Isn't it?
that is the statement of the police, Your Lordship.
Hmm?
I was arrested on 4th.
But there is also record that
I was
you were involved in.
arrested from my
you were
residence.
involved in some other case
On-
also,
on
similar
4th.
case.
Yes, habitual offender.
No, Lordship.
That
in
is
that case, I
reflected
was
in the charge sheet.
That is special 45 of 2023.
Okay.
In that case, I'm on bail, Lordship.
You are
On
on bail.
default,
Yes.
yes.
There is a condition on bail.
Yes.
I've also annexed that order, Lordship.
Okay,
That-
order.
that-
Does the order
relevant.
says anything that you can commit?
No, Lordship.
No.
In my case, Your Lordship, no recovery was affected from the possession, Lordship.
No recovery.
And yes,
Yes.
Lordship. And the law is very clear, Lordship,
Okay.
which I've submitted, Lordship.
Yes, no.
And only on the disclosure statement made by the,
Right.
yes.
It was only on disclosure
Yes,
statement,
Lordship.
yes.
And as per the FIR, that is what the police is saying. That
Okay.
is just an allegation, Lordship.
Okay,
And that will be proved by the prosecutor at the time of the trial,
okay.
Lordship.
Okay.
Moreover, this is a charge sheet case, Lordship.
Hmm?
Moreover, this is a charge sheet case, Lordship.
I think-
Investigation is complete. What's murdered for the investigation, Lordship?
Item 3, huh?
Yes,
It will
Lordship.
be Pakin Richabo. You're Pakin Richabo?
No,
No,
Lordship.
sorry, same. Looks same.
Nsukaji, Lordship.
Huh?
Nsukaji, Lordship.
Yes. Nis, huh?
Nsukaji, Lordship.
Yes, Nesukatis. And counsel for the petitioner. So, beginning similar with item 4,
Your
but
Lordship,
he is not pressing for the ground. But then I have
Lordship,
seen.
yes, this is a subsequent bail application. And since the rejection of the earlier bail application, there is no fresh ground warranting the interference of this honorable court.
No fresh ground.
Yes,
No,
your
Lordship,
your Lordship, I kindly see
then,
the
you
prayer.
Arrested on
Lordship, I was arrested from my residence on
case number
4/5/2025.
section same, huh? Arrested on
arrested from my residence on 4/5/2025.
2025
Yes, Lordship, from
Okay.
my residence in Dimapur.
from residence. Okay, and then you applied for bail,
Yes, Lordship.
rejected.
Yes. That was on the ground of arrest, Lordship, but I'm not pressing on the ground of arrest, Lordship.
So he has to show a cause for the invocation of this court's jurisdiction. There is no fresh cause.
When? See,
Yes.
I'm contesting this on merit, Lordship.
Merit.
Merit,
Lordship.
yes,
So on merit,
Your
your
Lordship.
bail was rejected.
Yes,
It appears.
Your Lordship,
No,
on merit, then I'll be relying on the charge
Your
sheet.
one of the ground is on for arrest is mandated under.
That
so-and-so
has been
was
already
never
considered by the
complied.
lower
Okay.
court, and
Just
it
a
has been
minute.
rejected.
On
Yes, rejected
When?
on 28/10/2025.
28.
Yes, page 16 of the application,
28/10.
28/10/2025. Relevant portion is at para 5,
Only
page
once it was
17.
rejected. How many times?
2 times, Lordship.
Okay.
Two times, but only one judgment has been annexed.
Yes, Lordship. Since the other council was taking up the case, Lordship.
Okay.
And
But then,
later on,
when it was rejected, have you?
since this is charge sheet, record this before you
Just a
hand,
minute.
Lordship.
When we need. When it was rejected?
Lordship,
The second.
next year, see, Lordship.
Hmm?
The next year, see,
No,
Lordship.
in the.
Page
That is-
16, Lordship.
You have only
28,
annexed only one.
2025, Lordship.
One bail rejection order you have annexed.
Yes, Lordship.
28.
28/10/2025,
Okay.
Lordship.
And where is the other one?
Other one is not annexed.
When it was rejected?
Lordship,
Twice. Bail rejected twice. Have you stated that you are also involved or in some other case?
yes, Lordship, that is 2023 case.
Where have you stated?
No, I have
There
not
is a
stated-
recent judgment and notification that you have to state if you were involved in some other case and what is the status of that case. Do you know that judgment and the notification of the High Court, where it says that you have to state the entire fact about your antecedent, the past records of
Yes, Lordship.
criminal
that's,
records.
Yes, Lordship.
Where have you stated?
I have annexed this bail order at page 22, Lordship, which was executed earlier, Lordship.
No.
2023.
That refers to another case arising out of different PS.
No, that is okay.
It has
Bail
nothing to do
rejection
with the
also,
present
yes.
case.
Okay. The ground would be that the accused was arrested merely on the basis of the alleged disclosure statement made by the co-accused persons during police interrogation, and such a statement and such a statement is legally untenable. Stop. 2 would be that no any illegal substance or incriminating evidence was recovered from his possession, nor seized any. No. Incriminating evidence was seized or recovered from the possession of the alleged accused person during the time of his arrest. Number 3 would be that upon completion of investigation, the case has already been charge sheeted, and now the case is pending at the stage of consideration of charge, and therefore custodial interrogation or remand would not be necessary, no longer be necessary for the purpose of trial. The last would be that the ground of arrest as mandated under section 47 BNSS was never complied. which makes the arrest illegal. Then the submission of the his arrest is 28/10/2025. Huh? So arrest is 4/5/2025. Huh?
Yes, Lordship.
Bail rejected on 28/10/2025.
Yes,
Huh?
yes.
Okay. Then submission, Miss Mary's submission would be one, that no fresh ground has been taken after the rejection of the bail by the trial court on merit. Two, that the record, that is same, huh? That the record, for the record, the ground of arrest, same as that of item 3, huh? Was communicated to the accused and his family, wherein he has acknowledged, and then he has acknowledged that he had been informed about the basic fact constituting the ground of his arrest in the language he understood, in the language he understand, and that he acknowledged the receipt of the said document. Okay. That the contraband substance involves which the suspected contraband drugs, huh? Cannabis, stroke, ganja, within bracket, huh? Where is a huge suspected contraband drugs, huh? Within bracket, cannabis, ganjas were recovered from the co-accused, weighing 370.6 kgs stuff, huh? That the accused next, huh? Is also involved in similar nature of offense, wherein he is on bail. Nature of offense, involving nature of offense.
Lordship, I've stated that in my paragraph 11 of my petition. Lordship.
11.
Yes, Lordship.
Huh? You were arrested earlier,
Yes, Lordship.
released.
In different
Yes,
case
Lordship. In
number.
different
Okay.
cases.
Yes.
But then here you stated applicant have no previous criminal record. This is misleading.
Misleading.
That where he
No.
was arrested, where
Lordship,
he
that-
was arrested
Done in
and released
written
on
mistake,
bail.
Lordship. My sincere apology, Lordship.
So for this statement, the person who submits should also go.
My apology, Lordship, that in written mistake, Lordship. But I have clearly stated in my paragraph 11, Lordship.
Okay. Then rest I'll dictate. Okay.
Obliged, Your Lordship. Grateful.
Item number 5.
Yes. Here, just one thing, I think two things. Whether the accused who is in jail need to sign wakalatnama
My lord.
question? Is
I'll
there
give the notification.
notification?
Yes.
Okay, then it will be clear.
Yes, my lord.
What it says?
May I read, my lord? Point 1. This is my situation.
Oh, this is Kohima bench.
Yes, my lord. Authorization letter signed by the accused with countersigned signature of the jail authority when the
Authorization
accused is in jail. And the petition application is filed by another person, my lord. This is my case. And the second one is what my lord was trying to convey. Wakalatnama signed by the
Wakalatnama
accused
signed by the accused.
with counter signature of the jail authority when the accused is in jail and application is moved by the accused himself. Then yes.
Okay, I think this is clear now. Okay, now the second question is, so he filed bail, default bail before the trial court. It was rejected,
Yes, my lord.
saying that it is 180,
180
not
days.
90.
Yes.
That may be incorrect. But then thereafter, subsequently you filed bail application before this court.
Yes, my lord.
When you file bail application before this default bail, this present bail application before this court, whether charge sheet was already filed or not?
No, my lord. That the prosecution can clarify also.
Yeah, whether when this was filed? By the way?
18/11/2025. 18/11/2025.
Just a minute. Filed on
18/11/2025.
just a minute. Earlier bail rejected on
On 6, my lord, just 1 minute. 6/11/2025.
okay. Just let
And
us,
also on
let
12
us just let us
Yes, my lord.
to begin with
first
from the
bail
beginning.
application.
Just when he is
Arrested
accused
on
of commission of offense. Let me see. Offense. What are the offense?
FIR was lodged on 23/07/2025.
23,
07/2025.
2025.
Yes, my lord.
Okay, under section
Under section 63A, bracket A,
63,
bracket A, bracket B, bracket D, bracket 6, 65, bracket 2, BNS, red with section 4, bracket 2, and section 8 of the POCSO Act.
okay, so first bail application was
First bail application numbered as IA 14
bail
of
rejected on,
rejected on 12/9/2025.
no,
12/9.
he was arrested on
Arrested on 24/7/2025.
24,
7/2025.
all of them,
Yes, my lord.
24/7/2025.
Yes, my lord.
Okay, bail rejected on
12/9/2025. 12/9/2025. And the second bail,
you file bail, okay,
second bail was rejected on 6/11/2025.
6, 11, 20. So second bail is default bail
Yes,
application.
my lord.
Okay. Rejected. This one was rejected. Okay. And then when the charge sheet was filed?
My lord, I don't have the copy of the charge sheet with me.
29/11, Your Lordship. 29/11.
29/11.
Yes.
Charge is filed on 29/11. Okay, when this bail application filed, you said?
18/11/2025.
There is after filing bail application before this court, it appears.
Yes, my lord.
Now I think, what is your submission? I think he is entitled.
Yes, Your Lordship. First and the foremost thing, Your Lordship, the entire petition of the petitioners is that, Your Lordship, because of the default bail which has been rejected by the special judge, Your Lordship, the petitioner is coming before this court. But Your Lordship, first and the foremost thing is that, Your Lordship, he's coming under 483, Your Lordship, inherent power, inviting the inherent power of this court. Yes, Your Lordship.
This is bail only?
Yes, 483.
Yes, on merit.
Yes, Your Lordship. Oh, Your Lordship, and he has not put into challenge the default. My preliminary objection is that he has not put into challenge the default bail, Your Lordship, which has been rejected by the special court. He has not put into
Have you
challenge.
taken this ground that you are filing this bail application on default?
Yes, my lord.
Yes, he
Where?
I have.
Where?
My lord, may kindly come to
has not
page.
put into challenge, Your Lordship. They say that
No,
like,
no,
it has
but
been
No, I do not
rejected.
appeal against bail order.
No, no.
There is no provision to
It is,
appeal.
it has, no, they should come by way of
Just a minute,
revision,
just a
Your
minute.
Lordship.
If he has stated that he is filing this as 90 days,
Page number 7, my lord, of my petition,
okay,
subclause B,
B.
that the accused are entitled to default bail
Yes.
as provided under section 183 subclause 3 of the BNSS.
Yes, Your Lordship, that's why.
And my
I'm-
lord, misleading.
No, not
No,
I have
misleading.
filed
It's
a-
just-
Just a minute, just a minute.
Application
are-
under 483.
Yes,
I have
sir.
not
Yes, sir.
invoked the inherent power of this honorable court. I filed the special power of the High
Discretionary
Court
power,
and
Your
the
Lordship.
Sessions Court regarding bail.
Yes, Your Lordship.
Yes, my lord.
That's why, Your Lordship, he should have come
The
by way
prosecutor is
of revision,
confused.
Your Lordship.
The prosecutor is
challenging,
confused.
No, challenging the, Your Lordship, the default bail which has been rejected by the special court. Your Lordship, that is the first thing. And secondly, Your Lordship, before the expiry, Your Lordship, before the expiry of the 90 days period, Your Lordship, the IO filed an application stating that there is a further need for examining the witnesses, key witnesses, and therefore some time was sought for, Your Lordship, from the magistrate, Your Lordship.
Under which provision?
Yeah,
Under which
Just a
provision?
minute, just a minute.
Yes, Your Lordship.
Can,
It's a special law, Your Lordship. It's a special statute. We are coming here because of the statute law, Your Lordship, POXO Act. We are not under any other law, Your Lordship.
No, what
It is a POXO law. That's why, Your Lordship, this honorable court has to, put a cautious mind while granting bail. Even if this honorable court deems fit that it should be given, Your Lordship, at least a cautious mind should be given, Your Lordship.
just a minute, you have to satisfy the court.
Yes, Your
that-
Lordship.
Because the statutory period
Yes, Your Lordship.
is 90 days.
Yes, Your Lordship.
So can the court extend? Under which provision?
Your Lordship, suppose, Your Lordship, if there is a key witness, because your ruling is there, Your Lordship, if there is a witness, if there is some,
Whether the court passed any order extending the date, extending the investigation period?
yes, Your Lordship,
Any order?
yes, Your Lordship, there is a ruling which says that, like, Your Lordship, if,
No, whether the trial court has passed any order.
no, that, Your Lordship, when this submission was met, unfortunately, Your Lordship, what happened is that on that day, Your Lordship, this matter, it was also submitted, that was before, before the expiry of 90 days, the extension was sought for by the IO, Your Lordship. Now what happened, that was submitted by the public prosecutor on that day, on the day when the default bail was put up, Your Lordship. Now unfortunately, Your Lordship, the magistrate was of the view that this matter again falls under detention and he has quoted 180 days, Your Lordship. And therefore, this matter was not focused. Otherwise, the submission of the prosecution was also there, which was also being objected by the counsel of the petitioner
Even by
in
mistake
the
also,
default
there
bail
is
also, Your Lordship.
nothing on record showing that the magistrate has extended.
Yes, Your Lordship, that
So then in that
specifically
case it will
to,
be difficult.
it's
It will
not
be
there, Your
difficult.
Lordship.
Oh.
Your Lordship, that is up to the mind of the court, Your Lordship. The thing is that what I am supposed to do, what,
But
on the
then why,
records, what...
just a minute.
Yes,
sir. Why you have filed only one bail application for 7 accused persons who was involved in a commission of the offense in a different time?
My lord,
On different
I have only one ground. I have only one ground, default bail.
Maybe.
Nothing on merit.
But then different bail applicant, different accused person, they are not connected with, all of them. None of them are connected with, separate incident it appears. And
My
why?
lord.
Yeah, because here, supposing some accused person may have committed or attempted only, okay? Maybe, not committed. and then some must have committed grave offense, okay? So in that case, do you expect that the bail condition will be the same? It cannot be, it will go to the highest one, isn't it?
My
Isn't
lord,
it? So
they
why you
are
have
all booked under the same section.
Maybe.
They are all booked under the same
maybe.
section. Now, presuming that they have not committed, they have committed, I cannot move bail applications.
It's always
They have all
safer,
booked
safer to
under-
file separate bail
Yes, my lord, I will do that the next time. But it's no harm filing same bail application for any number of cases, because they have only one ground before
We
that.
find sometimes difficult because in a case where the person only accompanied and the one person committed offense, but then bail, in one bail application, condition, you cannot put separate condition again. If it is a 2 lakhs for one main accused, it will go again.
But my
for
lord,
him also.
any
Him
condition
as well.
I'm willing to comply. Any condition I'm willing to comply.
So don't try to confuse the court also. And so separate bail application is always better.
Fine, my lord, I'll do that the next time. I'll take it.
Okay, so anything else?
Your Lordship, that is the only thing, because Your Lordship, my only submission is that now, Your Lordship, the charge sheet has also been filed as prayed for, though Your Lordship, as correctly stated, there is no order from the magistrate. The magistrate completely overlooked the fact that, yes, Your Lordship, 180 days, he was of the mind that like it is of a detention, and 180 days was quoted, Your Lordship. So because of that, like he was of the impression the statutory period was not over, and therefore there is no point of extending. Yes.
Here in this case, had the IO filed charge sheet before filing of this subsequent bail, before bail,
Yes, you-
then you see he has no right.
The
But then
submission
here is
has
a case
been made.
where,
Yes.
here is a case where the petitioner has already filed bail application on 18/11, and then the police has filed charge sheet only on 29/11.
Yes, that was
after.
because, Your Lord, before the expiry of 90 days period, Your Lordship, this was filed.
No, but then.
Yes.
There is no
Yes.
provision, there is
Should
no
have
provision, my
actually-
lord.
should have actually-
If there is any letter.
No, there is an
just
apex
say-
court ruling, we can
My lord,
substantiate, but on the later
Section
stage, we are
31.
having a lapses, Your Lordship. That's why I'm also not pressing it, Your Lordship. There's a ruling which says that even after, in a special law means it's relating to POXCO A. If it's a general law, Your Lordship, but in the POXCO, Your Lordship, if Your Lordship,
If you can show the authority.
it can be extended, but it, provided the magistrate has to record,
Yes,
Your Lordship.
magistrate
So
did not
that part we
record.
are
That is why I'm
failing.
saying.
I'm also admitting that. But the learned counsel should also appreciate that fact. Your
No,
Lord.
my lord.
See,
Okay.
There is no
So
provision.
just a minute, okay. You have anything to?
So, Lordship, since this is very limited to default bail, Lordship, I have very limited to say on it. And I'm representing only the informant. But my respectful submission is, Lordship, that this is a special statute to protect the interest of the child from social exploitation, sexual
That is
exploitation.
there, that is there.
So it has to be taken care of, and even the gravity of the offense has to be taken into consideration. Well,
That is why, see, the court is also giving a patient hearing. Otherwise, you see, that
that's why
record
we
is
are
clear.
also being sensitive because it's a POXO Act, Your Lordship. And taking
Although
into
the
consideration the
allegation is
Tarama,
grave, and
that is the
then
only thing. Otherwise, Your Lordship, we
these
also know the technicalities,
persons,
we also know the law.
elderly persons are involved. But then, what can we do? We can't change the law.
Yeah, that is Your Lordship.
Lordship,
As
my
deemed
concern
fit,
is
Your Lordship.
only with, supposing if this honorable court releases all the accused persons, my only concern is whether they will tamper with the evidence and the
So
witnesses.
that condition will be there.
Stringent
Of course,
condition
that
will be
condition will be there. So we'll put the appropriate conditions. Okay.
Your Lordship,
Okay,
our submission may be recorded, Your Lordship,
Okay.
regarding the sequence, how it has come about, Your Lordship, and especially the condition of the child trauma and all these
Okay.
things.
Heard Mr. A. Sophie, Ghana counsel for the petitioner. I've also heard Ms. Levika, Ghana PP for the state, and Mr. Moazami for the respondent number 2, informant, Mr. Parra. By this application, filed under section 483, read with 1873 of the Bharatiya Nagrik Suraksha Sanhita 2023, the petitioner is seeking release of 6 accused persons, namely in page 3, okay? their name, who have been arrested. When they were arrested? 23/7.
24/7. 2025.
23.
23 FIR was filed.
Okay, FIR, okay. Been arrested on 24/7/2025 in connection with the
GR 40 of 2025. In connection with Women PS case number 2 of 2025.
connection with women PSK. Which women PSK?
Women PS Denaboto.
Well, Junevoto Women PS case number 002/2020 stroke 25 under section 63A B D 6 Roman 6 stroke 65 2 B and S read with section 4 within bracket 2 and 8 POXO Act of POXO Act. Stop. The case of the petitioner is that after earlier, the Lanet Trial Court has rejected their two bail applications on 12/9/2025 and 6/11/2025. Stop. The second bail application was filed seeking default bail, seeking release of the accused persons on default bail as the police, as even after expiry of 90 days, the police failed to file charge sheet into the case. Default bail under section 187, 3 of BNSS, as the police failed, even after expiry of 90 days from the date of their arrest, the police failed to file charge sheet into the case. However, the said bail application was rejected by the Lanet Trial Court, stating that the statutory period is 180 days and not 90 days. Stop. Para. Thereafter, the present bail application thereafter was filed on 18/11/2025, seeking release of the accused persons on default bail as the police failed to file charge sheet into the case even after expiry of more than 90 days from the date of their arrest. Stop. The Land Council for the petitioner submits that if the police fail to file charge sheet into the case even after expiry of statutory period of 90 days, the accused persons are entitled for consideration of their bail under section 180 within bracket 3 BNSS 2023, and the court has court cannot exercise its discretion in this regard. Stop. Para. The learned public prosecutor, on the other hand, submits that this is sensitive case involves with the accused, involved with the commission of the offense, the accused committing offense. Involves with the offense under section POCSO Act. Okay.
Of a special statute.
Okay. Involves with the statute, special statute under POCSO Act. She further submits that the police, when
23.
okay, submits that on 23.
About to submit.
23,
23, 10/25, Your Lordship.
10/20/25, when the police could not complete. By then it was
Yes, the
yes,
90
yes,
days period was granted,
complete
however, could not
the
be completed
investigation
within 90 days.
statutory period of 90 days. Made a prayer before the special judge
Special
POCSO,
Judge POCSO.
POCSO Act. However, no any effective order was passed in the application made by the eye of the case.
Your Lordship, it was recorded, but it was recorded, Your Lordship, on the day the default bill was heard. But no specific order.
Although it founds it, although it was recorded in the bail rejection order, but no, if
When the
bail
default bill was heard.
when the default bail was rejected on 6/11/2025, however, no effective order was passed extending the investigation period. Stop. She submits that. No, then even if they extended also, see, no date. Thereafter, you see, now it's been.
That's why, Your Lordship, here's a little bit like
Therefore-
lapses is there, Your Lordship, lapses is there. It's just that like the court was under the impression it is on detention, and so he quoted that 180 days is a mandatory statutory spirit is there. That's why there is no need to grant the petitioner on default bail.
And
So that was the observation,
And
Your Lordship.
subsequently, the case was submitted into charge sheet on 29/11/2025. So therefore, while considering the bail, the gravity of the offense and the statutory special, what did you say? Statute, special
Statute, yeah.
statute.
It's a special statute.
Statute be also considered. Stop. Mr. Moazamir, non-counsel, appearing on behalf of the
Informant, respondent number 2.
respondent number 2, informant. So, support the submission of the PP. Okay.
Lordship.
Your Lordship, let it be our submission that like in the event this court deems that the bail should be
And
granted,
further
then
submits
stringent
that even if the bail is considered for release of the accused, a stringent condition may be imposed upon them considering the nature of offense and the nature and gravity of the offense committed by the accused persons. Okay. Hard. Okay. And then it will be released only. Okay.
Obliged, my lord.
Not on merit, huh? One.
Apologies, Lordship. Lordship, in item number 3, Lordship, if your Lordship may kindly reflect the judgment which I placed before your Lordship.
Okay.
In the order.
Mr. So-and-so, huh? The item 3, huh? Relied on the
Because,
judgment of the Supreme Court, both?
yes, Lordship. STC on the Lordship.
Okay, 2, it's there, huh? In support of his submission, relied on the following judgment, okay? Relied on the following judgment. Okay. Of this.
Obliged, Lordship.